Hello again, this is Legal Focus. Today on the program, an agenda setting for returning Minister of Justice and Attorney General of the Federation, Abubakir Malami San, and an exclusive interview with one of the foremost female senior advocates of Nigeria, Funke Adekoya. Later, crucial legal insight on the law of contract in Nigeria. Come along.
The Senate had on 24th of July commenced screening of the nominees made of 43 names, 14 of them former ministers in his first term. Among the returning ministers is Abubakir Malami, who had served as the Attorney General of the Federation from 2015 to May 2019. President Muhammadu Buhari on the 21st August reappointed Mr. Malami as Attorney General of the Federation. This reappointment by the President has raised reactions from lawyers who have divergent opinions on the President's action.
He is ordinarily to advise the President on issues like this. I'm wondering where the President is getting his advice from that would make him ignore court orders to this point. Where are we going to? Court orders are no longer obeyed. They now put, in quotes, national interests above the rule of law.
Some lawyers believe the President was not properly advised by the Minister of Justice on issues surrounding the judicial sector in his first term in office.
This AGF, who has been reappointed, against public and judicial opinion, breach and advise the government not to release or not to obey a valid court order, which have not been set aside. And you see, went before the Senate and tell the Senate that he advised the government not to. That more or less is abrogating the rights of trying and executing an enforcement of the law to himself, which to me is against the rule of fair hearing and rule of law. Ordinarily, in a sane climb or in a saner climb, he does not deserve to be reappointed.
It's better to say that they should also, make the plea bargain as a mode of, engaging the defense to bring up those approaches so that those issues can be resolved. Because if they are just all out for let's go to court, then it might be a Herculean task for them to secure convictions in view of the bottleneck in our system.
In 2010, Process and Industrial Developments Limited (PNID) struck a deal in which the Nigerian government will supply gas to a processing plant in Calabar, built and run by the firm. In 2012, PNID took the government to arbitration over an alleged failure of the deal and won the award, which was based on what it could have earned during the 20-year agreement. PNID claims to have expended $40 million in preliminary expenses on the accelerated gas development project in Nigeria's oil mining leases 67 and 123. But Nigeria's Solicitor General Dayo Akpata says the firm never began the construction of the project facility, and yet its claim was for loss of profit for the entire 20 years of the project. According to him, the claim started at $1.9 billion, but PNID later increased its claim to $5.9 billion. After the tribunal ruled that Nigeria had breached the contract, Nigeria successfully applied to have that award set aside by the Federal High Court in Lagos. He added that the arbitral tribunal headed by Mr. Justice Christopher Butcher ignored the Nigerian court's decision and on January 31, 2017, delivered the final award against Nigeria through the Ministry of Petroleum Resources. The tribunal arrived at the sum of $6.5 billion and together with pre-award interest at the rate of 7% per annum, effective from March 20, 2013, and post-award interest at the same rate till date of payment. This interest has increased the size of the award to a sum in excess of $9 billion. PNID's legal team now says it intends to begin the process of seizing Nigerian assets in order to satisfy the award as soon as possible. Nigeria's Attorney General has also vowed to probe what he calls the underhand manner the contract was formulated and signed by the past administration.
Nigerians woke up, unfortunately, on Friday, 16th August 2019, to the rudest consequences of the underhand dealings of the first administration that has resulted in the award of $9 billion judgment against the Federal Republic of Nigeria by a British court, which ruled that Process and Industrial Development Limited had the right to seize 9 billion naira in Nigerian assets. We shall not fold our arms and allow this injustice to go unpunished.
The Nigerian government concludes the damages were clearly unreasonable and manifestly excessive.
In the Constitution, we have that right to freedom of speech, and we call it a fundamental right. It is called fundamental because it is enshrined in the Constitution, and the implication is that you don't take it away from citizens without justifiable reasons. Now, talking about drawing the line between right to freedom of speech and engaging in criminality. Now, you must understand that every right has its own limitations. That's why in law we see ubi use ibi remedium. Where there's a right, there's a remedy. No right is at large. Every citizen's right ends where another citizen's rights begins. Now, if you look at the Constitution, all these fundamental rights contain what we call clawback provisions. There are exceptional situations, there are instances and circumstances which may warrant the government to curtail those rights or to temporarily deprive the citizen.
Someone came out a couple of days ago saying he wanted to organize a rally. Yes, of course, it tagged it as a revolution rally. Beyond the word revolution, what manifest intention can be associated with that use of term, with that use of expression? You cannot say. He hasn't even told Buhari to step down. He hasn't done that. He hasn't called for armed protest. He never did that. So before the government can begin to say this constitutes a threat to change the government forcefully, and then you look at the way the government clamped down on innocent protesters, seriously dragging men by these belts and all of that. Have they ever taken even a measure of that against other people that have also been beating drums of war? So beyond the issue of government trying to be proactive, at the center of this is the issue of sincerity of governance. And of course, when people are not in tune with the government, when they are at displeasure with the government, they have the right to protest. It's sacrosanct the world over. And unless we learn to take criticism, even if it is biting and harsh, it is of the government to accept and learn from that. Even when it's against you, it's also for you going to accept that in good faith and move on from there.
You're watching Legal Focus on TVC News. Our advocate for today is Senior Advocate of Nigeria, Olufunke Adekoya, a principal partner here at ALEX, based in Lagos, of course. You're welcome to the program. We thank you too for this opportunity to come interview you about crucial issues about yourself.
Thank you very much. It's a privilege to have been invited.
Walk us through the beginning, how it all started for you, your journey to becoming a legal practitioner.
I've always wanted to be a lawyer. I've never given serious thought to ever being anything else. Maybe because my father studied law as an adult, so we saw him going to classes and he'd come back and talk about cases and things like that. So I've never considered maybe dramatic arts, but I've always wanted to be a lawyer. I graduated in 1974 from then the University of Ife. Privileged to have come top of my class. The idea was that I was going to go back to the university and be a lecturer. And then I went to do my youth service in private practice, and I enjoyed it so much that even though I had applied for an LLM and had got a position, I went to do my LLM and I came back into private practice. That was the end of an academic career.
So, well, talking about legal influences that shaped your mind back then, I take it your father must have been, one of the major influences. What about, tell us about your father and other influences that helped shape your mind then.
Okay, well, my father was an influence in the sense that I grew up in the legal profession. My father qualified elderly, qualified in 1963. Immediately he came back from the UK with us. He then took appointment as a magistrate in Tanzania, and he was in Tanzania till 1969. Then he came back to Nigeria, took appointment as a magistrate in then Benue Plateau State. So I've lived extensively in both Benue and Plateau states. And so that was one influence. I grew up in a legal background. There were strong concepts of what is right and what is wrong.
Right.
I then started my youth service in Kaduna at a time when we were the second set of women as lawyers to do youth service. So we were an anomaly. I was lucky to work in a law firm, Abdullah Ibrahim and Co., where there was no restrictions. It was a question of competence and ability to work. And so issues then as to we don't want a lawyer to represent us, which were quite common in the early 70s, he just firmly stamped it out. So my mindset has always been, you're not a woman lawyer, you're just a lawyer. And I've had that attitude ever since. Other influences, Mrs. Hairat Balogun. I did my law school attachment with her when I was in law school. And she explained issues of work-life balance, time management. One of the things she said then was, if you want to be a lawyer and you want to be a mother, you have to balance the two. Other influencers, my career in arbitration.
Right.
Chief Mrs. Tinuade Oyekunle. She was, I think, the forefront. I complained one day about litigation. I was in court, my matters were not going on, I was frustrated. And she said, have you considered the alternative? So people you meet along the way tend to have an influence on one's life. These are the people I would consider to have been influencers.
There's so much to know about you, but let me just take it as the thoughts come into my mind now. Private practice. So you learned all this and then you ventured out on your own private practice, so to speak. What was that period like? What would you pinpoint as the highs and the low moments?
Highs and the lows in private practice. I can tell you the low moment was taking a pro bono matter before a federal high court, asking for an injunction to be argued in time so that a candidate who had been refused admission or whose admission from the University of Lagos had been withdrawn could be allowed to matriculate. The low moment was the judge didn't understand what matriculation was. And he kept on talking about, I did matric. And we kept on trying to explain that the university will have its matriculation on such and such a date. If we can't argue our application before that date,
you would miss it.
We'll miss it, and the student will not be able to matriculate, even if the injunction is successful. That was a very low moment. High moments, many. Because as a woman, everything, every step is a high moment. But I would say collapsing my practice as O. Adekoya & Co., dispute resolution, into ALEX and forming a full commercial law firm was a high moment. Because for me, it was the ambition, it was a dream that we should have large law firms that could cater across the cadre of legal services. I think that was a high moment. Another high moment, obviously, becoming a senior advocate. As a woman, I was the 5th. There weren't too many around then. There still are not.
Still aren't.
But high moment. Then being nominated by the chairman of the World Bank, to join the ICSID panel of arbitrators. For me, very high moment. First Nigerian to be nominated by the chairman of ICSID. So I thought that was a high moment. Also being appointed to the World Bank Sanctions Board, which is a board that looks at issues of corruption, lack of ethics, fraud in World Bank contracts. High moment, because it meant that the image of Nigeria was not all about Yahoo, Yahoo, and 419.
I'm looking at more than 45 years experience in active litigation and arbitration, and like you rightly said, we're having a less than 5% entries of females who have become senior advocates of Nigeria. What's been done? What can be done, to increase this number among the senior league of lawyers?
Well, I think the ball one is in our court. I think we still have the issues of a workplace environment that is friendly to women. Because if you need appearances before the courts and decisions to be able to apply, which is the basis, we need to have law firms trusting competent women to take serious cases that will be able and carry those cases through from beginning to end, so that they would have those cases to attach to their portfolios when they're applying. So I think it's still for us in the profession to stop saying there are no women at the bar, because there are. And we need to acknowledge that and give the space to allow the women to grow. We're just as competent if we have those opportunities.
So
but in many instances, we're not given those opportunities.
So by saying we're all men, there are no women, it's basically a man's profession, not acknowledging that there are female genders in the legal profession is not helping the women eventually.
Exactly. It doesn't acknowledge what we do, because it's, oh, there are no women at the bar. And once you say there are no women at the bar, then you don't take account of the special requirements of women in any profession. In ALEX, we have a creche for our younger women lawyers who are still raising a family, so that they can work with a mind at rest, that their children are well taken care of. But if you say there are no women at the bar, then you don't take account of the fact that a woman has other responsibilities that society expects her to fulfill, in addition to being a full-time lawyer. That's my complaint about, oh, there are no women at the bar. Of course there are women at the bar.
So what next for arbitration in Nigeria? We've seen lawyers talking about, the lapses in the system. But for you, you've been an active practitioner. What's next? What is the next ground to take over now?
For me, two things. The first thing is we need to amend our federal arbitration law. The Lagos state law is more up to date and more modern, but more people use the federal law. So we must amend the federal law and bring it up to date with the UNCITRAL model law, because that makes us internationally recognized and acceptable. The second thing is that Lagos, especially now that Nigeria has signed the African Continental Free Trade Agreement, have a huge opportunity to be a regional hub for arbitration disputes in West Africa. And we need to push that agenda.
So looking at the legal profession, what's been your observation? What would you like to see changed?
I would like more emphasis on ethics in the legal profession. The amount of time that is being given to teaching ethics in the law school is insufficient. And the question of ethics is not something that should even be taught in the law school. It should run through the whole legal career. So from the universities right up to the law school and thereafter. I think that we need to emphasize the point that lawyers should be held to a higher standard. A Nigerian who had qualified as a solicitor in the United Kingdom in 2015 and who had become a member of parliament and who had been recalled because she had lied about a traffic offense and was jailed for 3 months. The Solicitors Disciplinary Council have withdrawn her license, so she's no more allowed to practice as a solicitor for being involved in an act of dishonesty. Now, would that happen in Nigeria? The chances are it wouldn't. There are so many lawyers who have been involved in less than ethical conduct who are walking around today. And nothing has happened, either because nobody has complained and because our regulatory body has not deemed fit to say, we read this law report or we read this thing in the paper. A lawyer is being accused. Come and answer.
But are you talking
so we need to teach ethics, and we need to enforce.
Right. Are you talking from personal experience? Because I know you chaired the Legal Practitioners Disciplinary Committee. So were there challenges in the system that didn't give?
There are challenges in the system. Right. I chaired it was then the Bar Association's investigative committee. And in many instances, once there's something that looks like it may be newsworthy and it's a lawyer who's being investigated, our job was to decide whether there was a prima facie case, and if there was, send it to the disciplinary committee.
Right. Senior Advocate of Nigeria, Olufunke Adekoya, Principal Partner here at ALEX, we thank you so much for this interview. We are indeed honored.
Thank you. The pleasure has been all mine.
And that's been The Advocate today on Legal Focus. There's more on the program. Stay with us.
Welcome to today's segment of You and the Law. Today, we'll be examining the law of contract and basically what a contract is, the types of contract, and if time permits, the elements of a valid contract. What is contract? Contract is an agreement between two or more people to carry out a specific obligation. This is where people mutually agree that they want to perform certain duties and they commit themselves to be bound by those obligations. What are the types of contracts that we have? There are various types of contracts. We have written contract. We have parole contract, which is oral contract. We also have other classification of contracts that time may not allow us to explain in details. But suffice it to say that for a contract to be validly created in law, certain requirements, certain elements must be present. The most important are as follows. Number one, there has to be valid offer. In other words, someone has to make an offer to another person, and that person in law is known as the offeror. The offeror is the person that is saying, I am offering you so and so, I want you to consider it. An offer has to be definite, another offer has to be specific. When an offer is made, there has to be what we call an acceptance by the offeree. An acceptance is where the offeree commits himself to the terms of the offer as made. And that acceptance the law requires must be unequivocal. In other words, if someone is offering to sell a television set to another person, Mr. A is offering to sell an item to Mr. B. Mr. B, in accepting to buy that item, must not make a counter offer to say, okay, you are offering me this item for 5,000, I want to buy it for 10,000, or I want to buy it for 2,000. In law, that amounts to a counter offer and not an acceptance. So for there to be an acceptance, it has to be definite, it has to be unequivocal. When there is an acceptance, what is the other requirement? There has to be a consideration. A consideration is what moves from one party to the other, the benefits and the detriment. Where, for example, someone is making an offer to sell an item, the consideration is the money that is paid for the purchase of that item. And in law, there can be no valid contract without consideration. And what do we mean when we say there is consideration? It means that someone has suffered a detriment. The offeree has suffered a detriment. And of course, the offeror too has also suffered a detriment. So that consideration must be moved, has to move from one party to the other. It need not necessarily be in cash. It can be in the nature of services. It can be in the nature of an undertaking to do something or not to do something. Consideration in law need not be adequate. What the law is interested in is the sufficiency of consideration. In other words, where, for example, someone wants to purchase an item, and that item ordinarily, by market value, ought to be sold for 5,000. The law says that item need not be necessarily sold for that amount for that consideration to be valid. In other words, that consideration need not be adequate. It just has to be sufficient. Meaning that an item that ordinarily ought to be sold for 5,000 can in law be validly sold for 500 naira, provided the parties have mutually agreed, provided there is no element of fraud, there is no element of undue influence, and so on. Now, what is the other element of a valid contract? The parties must have an intention to create a legal relationship, or what we call legal relations. What this means is that why the parties have made why an offer has been made, an offer has been accepted, there is a consideration for the creation of the contract, there has to be an intention to create a legal relation. When that intention is absent, the animus in law, when that intent is not present, then there can be no contract. So that is very, very vital. And of course, as I did say, contract need not be in writing. Contracts can be made orally, provided the terms are not disputed, provided the terms are agreeable. Again, I must also say that when there is intention to create legal relation, the law also requires that both parties should have the capacity. They must have the capacity to perform that contract. For example, a minor cannot enter into a valid contract. A person that suffers mental disability, infirmity of the mind or of the body, and that deprive that person of the capacity to understand the nature of the transaction, cannot enter into a valid contract.
And that's Legal Focus. Thanks a lot for watching. See you next time. Bye-bye.